Hello students, this is Dr. Rajamugli Amrishetty, practicing company secretary, corporate legal advisor and insolvency professional. Being insolvency professional and also author of a book on lectures on insolvency and bankruptcy laws, I am confident to properly elucidate this topic and I am glad to be part of this knowledge sharing mission. Friends, in this part of lesson, would like to detail about the genesis of insolvency and bankruptcy law. Mainly we will cover need to have this law and what form ultimately the law is evolved. Dear students, as we all know, law evolves based on expediency prevailing at that particular time. It is pertinent to mention that almost all the acts in the preamble starts with whereas it is expedient. It is hereby enacted as follows. This means expediency is given the priority. Therefore, circumstances prevailing at that point of time forms the basis for enactment of any particular law. In this regard, it is important to understand how economic expediency have resulted in enactment of present Insolvency and Bankruptcy Code 2016. To really understand this law, we need to understand the reasons from pre-industrialization stage. Obviously, the expediency at the time was promotion of industries and business for balanced economic growth. As we know, establishing large scale industries and business requires huge capital investment, which is beyond the pulling abilities of sole proprietor or partnership firm. Therefore, during the year 1600 itself, East India Company was established in India. The concept of limited liability evolved during this 1600 year itself, enabling mobilization of capital and conduct of business by corporate entities. In order to regulate such forms of limited liability business, enactments like Companies Act and Industrial Development Regulations evolved in the 17th century itself. Subsequently, when the companies were reasonably established, expediency was shifted to protect the dependents on the companies like workmen, depositors and lenders, etc. And hence, various laws and regulations were enacted to protect the stakeholders. Thereafter, corporate entities downfall started because of increase in the cost of labor, economic liberalization, competition, excessive borrowing and siphoning of funds, etc. Therefore, legislations were passed to protect such sick industries like Sick Industrial Companies Special Provisions Act 1985, etc. But misuse of protection was available under SICA was maximum utilized by the industrialists, which resulted in delay in decisions of the BIFR and the mounting of NPAs, non-performing assets and accumulation of debt due to banks. It is not exaggeration to say that lakhs of crores of public money was held up in few sick companies. Revival of these companies, and if revival is not possible, liquidation of such sick companies was felt really necessary. Therefore, what happened was the need was felt to have comprehensive insolvency and bankruptcy law. You may observe the cycle of change, from 17th century to 21st century. In the first phase, what we have seen that various laws were enacted to promote the industries, because industries was necessary. In the second phase, laws were passed to protect the stakeholders on such companies. In the third phase, laws were passed to protect the sick companies. And what happened in the fourth phase? Comprehensive law was passed to rehabilitate sick industries. And if it is not possible to liquidate such companies, with a paradigm shift in the concept to suit the present economic expediency. You may please observe that the main concern of law is the regulation and balancing of the socio-economic and political interest. In regulating the economic front, law must take into account the negative economic impact and social economic problems. With the concept of globe as a village gaining the momentum in the 21st century, the economic activity of a country has impact on the other countries as well. Particularly from the year 1991, when Indian economy was liberalized, India is caught in a fast moving economic cycle and competition. It is like a riding on a ferocious lion. One should ride cautiously. If he gets down, the lion will kill him. Therefore, India should resort to reforms from time to time on par with the development in other countries, else the country will be ranked nearer to 200 out of 200 for ease of doing business, and cannot compete with the other countries. Therefore, there is a need that we need to continuously change the laws in India. Considering the importance and the need for reforms in the insolvency law in India, the Ministry of Finance, Government of India constituted Bankruptcy Laws Reforms Committee, which is famously known as BLRC. This BLRC was constituted on 22nd August 2014 under the chairmanship of Dr. T.K. Vishwanathan. We ought to know about this gentleman. He is a legal luminary. He is a Padma Shri awardee. He has played a crucial role in drafting of Information Technology Act 2000, the Competition Act 2002, the Right to Information Act 2005, etc. See, this committee, after a detailed study, has reported in November 2015. This is an elaborative report consisting of 2 volumes. Volume 1 deals with the text of the findings, which is very, very important. Every student ought to read thoroughly this. And volume 2 is the draft of Insolvency and Bankruptcy Code. So, BLRC report is one of the milestones in the history of Genesis of Insolvency and Bankruptcy law. BLRC examined all the existing laws. It is not exaggeration to say that they have gone into all the existing laws, particularly the laws such as Presidency Towns Insolvency Act 1909, Provincial Insolvency Act 1920. Students, please observe, these are the acts during 1909 and 1920, which are very, very old laws, and everybody, even if you observe, you will feel that there is a need to replace these acts. And Companies Act 2013, Limited Liability Partnership Act 2018, Sikh Industrial Company Special Provisions Act 1985, which is famously known as SICA, and SURFACI Act 2002, Recovery of Debts and Bankruptcy Act 1993, Recovery Provisions of Income Tax Act 1961, Enforcement Provisions of the Contract Act 1872, Negotiable Instrument Act 1881, relevant provisions of CRPC, relevant provisions of CPC, and laws dealing with employees, that labor laws, like various labor laws were there, various laws like RBI, SEBI, MSME restructuring acts were also looked into. After examining all these legislations, they have given this report. It is not an exaggeration to say that one need to study the BLRC report, as I stated, thoroughly one need to read that, and you will observe that there is a paradigm shift in the law, and this paradigm shift in the law we will study in detail later. We are now studying only the genesis of the law. Now, friends, also please observe that this particular Insolvency and Bankruptcy Code is nothing but what is mentioned as second volume of the BLRC report. There was no change. The Parliament enacted this law as it is, as reported by the Vishwanathan Committee. Now, let us understand the meaning of each word used in the title of this code. Insolvency and Bankruptcy Code 2016, it is said. Now, why they have used the word insolvency and bankruptcy when the words are same? This we have to understand. Students, please understand the words insolvency and bankruptcy are used together rather in the form of the phrase generally in almost all the places to indicate the financial stage of a person. It may be noted that insolvency is the inability to pay money, debts when they are due. It is financial status. Please note that it is only a financial status, it is not a bankruptcy as such. By repaying the debt due, the insolvency stage may be cured, but bankruptcy is not that. Bankruptcy is the final alternative when other attempts fail. Legal process to declare a person as bankrupt will be started by following due process of law. So, friends, please observe there is a difference between insolvency and bankruptcy. So, they have cautiously used since there is a necessity. It may also be stated that in the insolvency is the first stage of the bankruptcy. Thus, insolvency is the financial state of being bankrupt, but bankruptcy is the process of declaring a person as bankrupt. So, resolution under insolvency and bankruptcy law involve two different phases. That is, phase where insolvency is identified, it is referred to insolvency resolution process. If resolution is not reached, that is, if it is found that is not able to be restored back, then the second phase of declaring the person, that is as bankrupt, is triggered, which is referred to as bankruptcy process or liquidation process. Per provisions of IBC, an application to NCLT may be made under section 7 to 9 of IBC if there is a default in payment of debt. Students, please understand the default is criteria here. Whether is a insolvent and not is not the criteria. Suppose if the company is unable to pay 1 lakh and more once upon a time, now after the COVID it is 1 crore and more. If the company is not able to pay either to the operational creditor or to the financial creditor, it is deemed as a default. The term default has been defined to mean non-repayment of the debt, whether whole or in part. Even if the part is not paid, it becomes a default. This means petition can be filed when there is a default irrespective of the insolvency of the debtor, and it would fall within the purview of the default as defined under the IBC. Once application is admitted by NCLT, insolvency professional will be appointed by NCLT for conducting the corporate insolvency resolution process. These things about the process of CIRP and how the NCLT will find that the company has defaulted, etc., we will discuss in due course in the next lesson. What is the difference between act and code? Friends, it is pertinent to mention that when certain acts are consolidated to make it as a comprehensive law, it is called code. Certain acts, mainly in this case SICA and Provincial Insolvency Act and some other related laws, were consolidated and made this as a code and made this as a law. Therefore, it is termed as a code, that is Insolvency and Bankruptcy Code. Now, we have clearly understood the difference between insolvency and bankruptcy and what do you mean by code. So, then now we have understood each of the term used in this code. Then, however, friends, there are alternative methods also for recovery of the debts. When the due amount is not paid, there are other remedies to recover. They are briefly mentioned below. They are formal process of recovery has been mainly following three processes, that Negotiable Instruments Act. Students, you all know that check bouncing cases, section 138 is a commonly used, which comes under the Negotiable Instruments Act 1881. An offence under section 138, that means when the check is bounced, it is deemed as a crime, which is very important. So, once it is a crime, the debtor will be afraid, because the point is, in case if it is not honored, then he may be penalized. So, since there is a crime, it is deemed as a crime. So, the process of taking debtor through Negotiable Instrument Act itself has a deterrent to default. Now, there is a second method, Recovery of Debts and Bankruptcy Act 1993 also gave certain remedies to recover the debts by the banks. Similarly, Surfacing Act 2002 also provides sweeping powers to the banks and financial institutions to recover non-performing assets. They are authorized to take possession of collateral security without court intervention, which is absolute power, of course. Similarly, there are powers under CPC, and which the code CPC also explains various concepts and fills the gaps in execution of various provisions of both the Presidency Towns Insolvency Act 1909 and Provincial Insolvency Act 1920. Though there are other remedies, why they felt there is a necessity to bring out the present enactment is very important to understand. Banks which have given money and the corporates are not paying and the banks have no teething power. Of course, the existing laws are there, but still the powers were not adequate. Therefore, they felt that there is a need for this comprehensive law. Students, please understand that this is a central government enactment and the parliament, that is central government, has the power to enact laws on the subject listed in the list 1, union list, that is called union list. State governments have got powers to enact the laws on the subject listed in list 2, that is state list. So, either central government or state government can enact the laws on the subject listed in the list 3, that is concurrent list of the 7th schedule of the Indian Constitution. Central government thus, by virtue of its powers conferred under the schedule 1, has enacted this law. Therefore, it is held by the Supreme Court in various cases that the insolvency, bankruptcy is the item specified in entry 9 of list 3, that is concurrent list, and entry 43 of list 1 dealt with incorporation, regulation and winding up of trading corporations, including banking, insurance and financial institutions. Therefore, they said the particular legislation, that insolvency and bankruptcy code, is constitutionally valid and parliament has got power to enact the laws on IBC. Now, friends, the Supreme Court, because they have felt that there is a necessity to bring out a stringent economic legislation, particularly the Justice Mr. Nariman, who is the father of this legislation, who protected the law everywhere whenever the matter reached the Supreme Court. Some of the observations of the Supreme Court is worth mentioning at this stage before we get into the provisions of the Act. The Supreme Court has said that, as rightly enunciated in the objects of the code, some of the important observations of the Supreme Court of India in the matter of Innovative Industries Limited versus ICICI Bank and other, and Swiss Ribbons Private Limited and another versus Union of India. Referring to the statement of objects and reasons of IBC, the Honorable Supreme Court emphasized the existing framework for insolvency and bankruptcy is inadequate, ineffective and results in undue delays in resolution. Therefore, the proposed legislation as effective legal framework for timely resolution of insolvency and bankruptcy, which would support development of credit markets and encourage entrepreneurship. It will also improve ease of doing business and facilitate more investments, leading to higher economic growth and development. Friends, what happened was, at this stage, let us recollect that lakhs of crores of money was held up. The banks were unable to pay or lend the loans to the common public or new entrepreneurs. Therefore, BLRC also said we need to have some stringent law to recover all these dues. Then they have come out with this legislation. The Supreme Court thus observed, as per the data available in the World Bank in 2016, insolvency resolution in India took 4 years 3 months. That means, to resolve a dispute which was much higher when compared with the United Kingdom, where it is reported as 1 year, USA 1.5 years and South Africa 2 years. The World Bank's Ease of Doing Business Index 2015 ranked the India as country number 135 out of 190 countries on the ease of resolving insolvency. Dear students, it is worth noting that the foreign investors will come and invest in India only when we are ranked within first 20 or so. You are ranked 135 out of 190, which is a bad scenario. That is, there is no ease of doing business. So, therefore, there is a need to bring out a lot of economic legislations. IBC, Insolvency and Bankruptcy Code 2060, is a result of this. Referring to the observations of BLRC, the Honorable Supreme Court quoted, "This is a matter of critical importance. India is one of the youngest republics in the world with a high concentration of most dynamic entrepreneurs. Yet, these game changers and growth drivers are crippled by an environment that takes some of the longest times and highest costs by world standards to resolve any problems that arise while repaying dues on debts. These problems led to grave consequences. India has some of the lowest credit compared to size of the economy. This is a troublesome state to be in, particularly for young emerging economy with an entrepreneurial dynamism in India. Such dynamism not only needs reforms, but reforms are done urgently. The limited liability company is a contract between equity and debt. As long as debt obligations are met, equity owners have complete control and creditors have no say in how the business is run. When the default takes place, control is supposed to transfer to the creditors. Equity owners has no say. Please let me explain at this juncture. The BLRC led by Dr. Vishwanathan very clearly said the promoters have borrowed money. They are equity shareholders. So, once the company is unable to pay money, the bank's IRP will be appointed, the board of directors get suspended. So, the shareholders power, that is equity shareholders powers, gets lost and the creditors will take control. That means, banks will take control. This is a paradigm shift. So, this is a very good step. Regarding the working of the code, Honorable Supreme Court also said, we are happy to note that the working of the code, the flow of financial resources to the commercial sector in India has increased exponentially, which is as a result of financial debts being repaid. So, that means, lot of monies which are held in the sick companies are recovered by the banks, otherwise banks would have become sick by this time, please. So, this is how the legislation has empowered the economy, and the Supreme Court itself said exponential increase, that is very important word they have used. What they said is approximately 3,300 cases have been disposed of by the adjudicating authority based on the out of court settlements, and between the corporate debtors and creditors, which themselves involved claims amounting to rupees 1,20,390 crores, which is very huge money within a matter of 2 years, and 80 cases have since been resolved by resolution plans being accepted. Of these 80 cases, liquidation value of 63 such cases is about 29,788 crores. However, the amount realized from the resolution process is in the range of rupees 60,000 crores, which is over 202% of the liquidation value. So, that means, you have recovered more than liquidation value. Banks are very happy. As a result of this, the Reserve Bank of India has come out with figures which reflect these results. Thus, the credit that has been given by the banks and financial institutions to the commercial sector, that is other than food, has jumped from rupees 4,952 crores in the year 2016-17 to 9,161 crore in the year 2017-18 and rupees 13,195 crores for the first 6 months in the year 2018-19. These figures show that the experiment conducted in enacting the code is proving to be largely successful. So, then they said, the Supreme Court has very clearly said the defaulter's paradise is lost. In its place, the economy's rightful position has been regained. Each and every person in the country ought to understand the importance of this legislation. The Supreme Court observations by the bench comprising of Chief Justice Deepak Mishra and Justice Kanvilkar and Justice D.Y. Chandrachud in the matter of Chitra Sharma versus Union of India. It said the IBC reflects fundamental change in the basic premise of debtor in possession to the creditor in possession. Please note that debtor in possession. Once upon a time, the funds were borrowed by the person, equity shareholders, he was in possession, he was managing. Once he is not able to pay, the shift is changed from debtor in possession to the creditor in possession, which is highlighted by the Supreme Court. The resolution is a market driven. No, resolution process anticipated and the provided in the IBC is the very important thing. That is what the observations of the Supreme Court. See, I need not emphasize much about the importance of this legislation. The Supreme Court itself has emphasized the importance of this, and as you know, because the industry is very strong, lot of cases went to Supreme Court, and Supreme Court, after considering various arguments by the leading stalwarts and advocates, has upheld the constitutional validity of this act. Subsequent to the enactment of the IBC during 2016, 8 amendments are there so far, because it is economic legislation. Lot of expediencies have been identified, and based on the expediencies and to revive the economy, these amendments have come. See, what was happening? Industrialists are very clever. So, once the company becomes sick, and before it became sick, they make the company sick. What they do is, they after sickness avail the benefits, one time settlement, two time settlement or whatsoever. Thereafter, they themselves submit the bid to take over that company after availing all the facilities. To avoid that, certain persons are prohibited from bidding. So, those are interested persons, same promoters cannot bid, and who are the persons who cannot submit bid to take over the company is laid down in schedule 12, which is very important. So, as this legislation is very comprehensive and it protects the economy, and it is the important thing as on today in the India. Thank you.